Introduction. The heart of risk management disclosure is one of the most critical responsibilities a real estate professional has, and in commercial real estate, it is often where the greatest legal risk exists. While fiduciary duties define how we serve our clients, disclosure defines how we protect everyone involved in the transaction. Arizona law, case law, and ADRE rules consistently emphasize that failure to disclose material facts is one of the leading causes of complaints, lawsuits, and disciplinary action. Under ACR 4-28-1101, agents are required to disclose all known material facts that are not readily observable and that could affect a party's decision. In commercial transactions, where financial, physical, and legal complexities intersect, this duty becomes even more important. What is a material fact in commercial real estate? A material fact is any information that would influence a reasonable person's decision to buy, sell, lease, or invest in a property. In commercial real estate, material facts extend far beyond physical defects. They can include environmental issues, zoning restrictions, lease defaults, tenant instability, pending litigation, access issues, or even changes in surrounding development. For example, if a property has a long-term tenant who is behind on rent, that is a material fact that must be disclosed. Similarly, if a property is subject to zoning limitations that restrict its intended use, that information must be communicated. The key question is always whether the information would matter to a reasonable party in making their decision. The legal standard, Arizona case law has consistently reinforced the duty to disclose material facts. In Hill v. Jones, 1986, the court held that sellers, and by extension their agents, must disclose known material defects that are not readily observable. This principle applies directly to commercial real estate. Additionally, Jennings v. Lee, 1969, emphasized that brokers have a duty to disclose material information and act with honesty and integrity. These cases establish that disclosure is not optional, it is a legal obligation. Failure to disclose can result in rescission of the contract, monetary damages, and disciplinary action under ARS Section 32 to 2153. Latent versus patent defects. Understanding the difference between latent and patent defects is essential in applying disclosure requirements. Patent defects are those that are readily observable upon reasonable inspection, such as visible structural damage. Latent defects, on the other hand, are hidden issues that are not easily discovered. Agents are not expected to discover latent defects through invasive investigation, but if they become aware of such defects, they must disclose them. For example, if a broker knows of a prior environmental contamination issue that has not been fully remediated, that is a latent defect that must be disclosed, even if it is not visible during a property tour. Environmental and regulatory disclosures. Commercial properties often carry environmental risks that must be disclosed. These can include soil contamination, underground storage tanks, asbestos, or proximity to hazardous sites. Agents must be particularly cautious in this area, as environmental issues can significantly impact property value and usability. Additionally, regulatory matters such as zoning compliance, building code violations, and ADA requirements can also constitute material facts. While agents are not expected to be environmental or legal experts, they must disclose known issues and recommend that clients seek professional evaluations when appropriate, consistent with ADRE policy guidance. Financial disclosures and investment representations. In commercial real estate, financial information is often at the center of the transaction. This includes income statements, rent rolls, operating expenses, and projected returns. Agents must ensure that this information is accurate and not misleading. Providing inflated projections or failing to disclose known financial issues, such as vacancies, deferred maintenance costs, or unstable tenants, can lead to claims of misrepresentation. Under the Restatement, Second, of Torts Section 552, agents can be held liable for providing false or misleading financial information that others rely on in making decisions. The role of the agent. Verify or disclose agents are not expected to verify every piece of information, but they're expected to exercise reasonable care. This means that if something appears questionable or inconsistent, the agent should investigate further or recommend that the client seek expert advice. ADR's Substantive Policy Statement Number 2005.13 emphasizes the agent's duty to assist in verifying information when warranted. For example, if a seller provides financial data that seems unusually high compared to market standards, the agent should question its accuracy before presenting it to potential buyers. Simply passing along information without consideration can create liability. Documentation and risk management. Proper documentation is one of the most effective ways to manage disclosure risk. Agents should document all disclosures in writing and maintain records in the transaction file. Under ARA Section 32 to 2151.01, brokers are required to retain transaction records, including disclosures, for a specified period. In commercial real estate, where transactions can be complex and involve multiple parties, thorough documentation is essential. It not only ensures compliance, but also provides protection in the event of disputes or audits. Real-world application. Commercial scenario. Consider a commercial property being marketed as a fully leased investment. During the transaction, the agent becomes aware that one of the major tenants has given notice and plans to vacate within 60 days. This is a material fact that must be disclosed to potential buyers. Failing to disclose this information could significantly impact the buyer's investment decision and expose the agent and seller to liability. By disclosing the information promptly and documenting the disclosure, the agent fulfills their legal obligation and protects all parties involved. Bringing it all together, disclosure as protection. Disclosure is not just about compliance, it is about protection. It protects the client, the other party, and the agent. In commercial real estate, where transactions are complex and information is critical, proper disclosure is the key to avoiding disputes and maintaining professionalism. Agents who understand and apply disclosure requirements effectively position themselves as trusted advisors and reduce their exposure to legal risk. As we move into the next section, we will explore how confidentiality interacts with disclosure and how to balance these two critical obligations. Online discussion. What makes a fact material in a commercial real estate transaction? Answer. A fact is material if it would influence a reasonable person's decision regarding the transaction. How do environmental issues impact disclosure obligations? Answer. Environmental issues can significantly affect property value and use, making them material facts that must be disclosed if known. What should an agent do if they question the accuracy of financial information? Answer. Investigate further or recommend that the client seek expert verification before presenting the information.